Well, hey, here we are live. I got to say, today is my favorite Monday morning, probably of all time. I've been thinking about this over the weekend, and a few developments have occurred. But Loper Bright, the decision came down. The decision came down in Chevron. The Chevron deference is destroyed. Now, here's the thing, not everybody's happy about it. Not everybody's happy about it, and some people are
No.
concerned, right, Keith? And Keith, I think, and with me today is John Richardson and Keith Redmond, and I want to start off with Keith today because Keith does live in the Beltway area, so he has
Well,
many
not
people.
really. I'm kind of here temporarily at the
Well,
moment,
I'm
but
sorry,
yeah.
Keith. You're around the Beltway
Yeah.
area, temporarily exiled in the Beltway area, but Keith, you're in it there. You're in it, and so Keith, why don't you just start? We'll start off today. Why don't you tell us about your conversation you had at dinner over the weekend about Loper Bright in the Beltway? Thank you, Keith. And Keith, by the way, is the consulate to and advocate for Americans overseas. Thanks so much for joining us today, Keith. So yeah, tell us about your weekend.
Well, I was interested because I had a family dinner the Saturday evening. It was for a birthday. And just through the course of the conversation, it was brought up about the Chevron case and the ruling that occurred. And I started talking about with the work that I do that this could actually be a good thing. Well, I was abruptly, not impolitely, but abruptly stopped saying, let's not talk about this. And I said, okay, why? And my cousin said to me, well, as you know, we have somebody at the table who works for the Social Security Administration and another person who works for NIH. And they both feel that this is an absolute disaster of this
Yes.
ruling. And I didn't pursue it because it was a family dinner. So I just
Right.
said, okay. And it just got me thinking that obviously you're happy, and I'm seeing where this could be a very good thing. But there is that other side where people are not very happy about
Right.
it.
Right.
Now, I think it would be a good idea if you and John don't mind for people to know what is the Chevron case and how was it overruled, because a lot of people don't know about what Chevron stood for.
Yeah, and we're so and essentially it's this. What Chevron did is it said this is like, look, if a statute, if a law is ambiguous or not clear, basically all these DC bureaucrats can invent the law from whatever they want. That's really what it is. So essentially what Chevron did is it made Washington DC a super state with basically nearly untouched powers. Over the years, the Chevron standard was like, hey, we're going to defer to agency deference on this. And I mean, it was basically a rubber stamp. It was basically a rubber stamp for any imaginable regulation that somebody unelected wanted. So I could imagine your friends who are used to all that power, about having all that power, unelected, unaccountable, would be distraught over losing all that power, because it's so much fun. Because this is the problem with it. We vote for people. They vote for they vote for these things, these laws that are very expansive and massive, but they're not the ones who actually to make the thing where the rubber hits the road. The law is the abstract. The regulations are the thing that gets you. Now, this is what's the problem has been, is that the regulations have been overboard. And really, and I mean, this is here, and this is what I would say, Keith. The number one reason why Washington D.C. in the 40 years since Chevron, the reason that all the counties around Washington D.C. have become the wealthiest counties in the world is because of Loper Bright. I mean, because of Chevron, because that deference just made, hey, look, it made kings out of all of these administrative heads, and
Well,
these administrative, yeah.
yeah, no, please, I didn't mean to interrupt. Go ahead.
Well, and that's the problem too, is like, well, who are these administrative heads? These administrative heads are usually failed politicians themselves. There are people like, oh, they ran for something, then they lost, but hey, they're a party loyalist, so we'll put them in there. And so that's the experts that the Chevron standards say, oh, you know what, courts should really just defer to these unaccountable political hacks as the experts. And so that's really what happened. And so that's what we have, ridiculous administrative states and things way out of control. And that's why Washington, D.C. is so incredibly wealthy at the expense of the rest of the country and actually the world.
So this is what I don't understand. With this ruling, that means that the onus is going to be on Congress when they legislate that they can no longer be ambiguous in what they write up. So it would make sense at that point, when they're writing up the legislation, that they consult these agencies and these experts before they write up the legislation and before it becomes law. So they have to be part of it before it even becomes law, right?
Well,
You
I mean,
follow my
Keith,
line of thinking?
well, no, I mean, they're already part of it. And unfortunately, a lot of the laws come from these exact, this is where they come from. They don't come from the people. These laws come from the regulatory agencies themselves. They just show up one day. Hey, look at this. We have a bill. It's like, well, that's a fancy bill you wrote there. You're looking at this senator. You've never written anything this complicated, and you clearly don't understand the law. So how
Right.
could you write an improvement to the law that's terrible? How is it even possible for you to do that? And the answer is not, because they didn't write the law. It just comes from them for the regulatory agencies. And so that's already going on. That's the problem. It already happened. And then this is really what we see happen, that Congress will intentionally not pass a law that's controversial. Why is that? Oh, because they will be voted out of office. So what they do is we'll vote for a law this way that says this, and then the regulatory agency, knowing full well what they want to do, already know what they're doing.
So they'll vote for a law that's intentionally ambiguous.
Yes, exactly. That way they can't say, "Well, I never voted for that law. I never voted for that. These regulators. They did it. You can't blame me." But it's a partnership. It's really a partnership between, the purpose of our Congress is just to ratify things other people create. They don't make laws. They don't even understand what they do anything. So their purpose is just to give cover. Really, I would say that the purpose of Congress is to give cover to the regulatory state that really rules over us, because they're unaccountable. You can't get rid of anybody. You can't get rid of a commissioner. If you disagree with them, you're not going to do anything. They are ultimately a say. So, I mean, this is why Loper Bright is just rocked the boat unbelievably, because it really, I mean, it is knocking over, and now people are running for cover and freaking out. And by the way, and I don't know, I just saw this morning. Let me see if I can get the screen share up. Unfortunately, it's behind a paywall, and unfortunately, I can't share what's behind that paywall. But let me see if I can get that up in a second. But I do want to, before I do that, there's a great summary on what John shared with me this morning, and so this might be a great summary to go over before we get into John's slides, which really are incredible, and he really pointed some things out. You definitely want to check those out. So, John, I'm going to go over to you. Well, good morning to you, my friend. Good morning. The great John Richardson talking about Loper Bright. I don't know what could be better than this. I mean, really, what a beautiful Monday. So, John, I want to thank you for this link you sent over this morning, which I think does a great job of explaining, what it is. And I would just say this, even my legal colleagues, even people maybe not in my world, a good friend of mine I went to law school with, she said, well, isn't that bad? This seems like Loper Bright would be bad, because this just seems like it's going to give more power to these big businesses and corporations, because now they could come up with any regulations they want. And I would say, well, actually, no, not at all, because you need to understand the dynamic. You need to understand the dynamic that big businesses actually love these complicated regulations, and they actually work in concert with our DC overlords. They work together. Okay, because what they want to do, look, here's the thing, and I think Loper Bright itself is a perfect example of this dynamic, because this is what happened. That, look, if you have a large factory fishing vessel, and that's what this case is about. It's about overseeing fishing. If you have a large factory fishing outfit, employing 2,000 people on board, even 100 people on board, you're making so much money, and you're kind of pulling out a lot of resources of that ocean, for you to have to pay for for a government observer on your boat, it's really not a big deal. It's really not a big deal whatsoever. It doesn't impact your profit line whatsoever. But now, as a case with Loper Bright, well, what if you have a much smaller crew? What if you have a boat that's fishing and has a much smaller crew? Well, there's only 6 people on the boat, and now number 7 is a government observer. Well, and that government observer is making more money than the captain, who's risking everything. So that's what this case is about now. And this is the thing, big business loves Chevron, because think about it. Your competition is where's your if you're a big business, where's your big competition coming from? Everybody else in the space. Those smaller ones who know how to hustle. Those are the ones they could come in with a value proposition that can knock you off and take over your advantage in the marketplace. So this is the collusion that happens. Imagine that large victory. The large interests don't mind these regulations because they could easily afford them, and then it creates a beautiful barrier to entry for any competition, therefore ensuring big businesses stay in control. So with that little, I want to get into this, John. Thank you so much, John. And so let me, John, good morning to you. Now that I actually will introduce you. So this is a case, John, you sent over to me just this morning, and I think it's really, really wonderful. I think it might be a good idea just to read this. What do you think, John? Oh, I do like it.
Yeah, sure. I think maybe you should read an excerpt of it. Yeah.
All right. So this is on June 20th. So today, in a 6-3 decision authored by Chief Justice John Roberts, the Supreme Court overruled Chevron versus Natural Resources Defense Council. Hold on, let me just say that again. Today, in a 6-3 decision, Chief Justice John Roberts, the Supreme Court overruled Chevron versus Natural Resources Defense Council. The court's ruling represents a tremendous victory in the fight to curb government overreach. Last July, we filed an amicus brief in this case, urging the courts to overrule Chevron. Today, the Supreme Court did just that in Loper Bright Enterprises versus Gina Raimondo, agreeing with us that it was long past time for Chevron, the case that has been used to give countless administrative agencies immense and unchecked power to go. 40 years ago, Chevron completely distorted the separation of power principles that this nation was founded upon. That case mandated that courts defer to an administrative agency's interpretation of a statute when the statute is silent or ambiguous. The alarming effect of Chevron was to put the power to interpret what a law means into the hands of the bureaucratic agencies themselves rather than the judicial branch. As a result, the administrative state's power grew out of control. And I think that's a pretty good place to stop there, John, and give an introduction as we move over to your presentation. Good morning, John. So how was your weekend, by the way? Were you thinking about this? Were you thinking, oh my God, here it is?
I think it's an important case, but I don't think I think it's going to, there's an old Chinese saying, somebody was asked, what was the historical impact of something that, happened, in 1850? And the answer was, well, how would I know? It's only been 130 years or something, right? I think it's obviously good news. It's obviously helpful, but I don't read it as broadly as a lot of the commentators do. But that said, I've got to tell you that I am absolutely not an expert in the administrative law area either. Okay. So maybe that's good. Okay.
Well, and I think there's a reason why. And there was because Loper Bright, and I think we'll get into that. Loper Bright revealed the confusion that bugged me all the time. It always bugged me, and I think that's what helps. It actually helps me understand what occurred a little bit better over the years.
I mean, I think it's actually, a much better sort of introduction and exposition of the issues than, some administrative law class in law school. That's for sure.
Yeah.
But I mean, there's no doubt this is good. There's no doubt this is good.
It's fantastic. And yeah, so let me just check in. I do see we're getting a ton of comments so much here. Oh, we want someone to link to the channel. You got, I'm going to put the link to the article I was just referencing in the super chat. So you'll see that there.
Yeah.
All right. So fantastic. So we're going to make sure we get to all the questions, and I've seen other questions people have, and we'll get those to it. And one of the questions I have is, how does this inform
this? I think it might be helpful to just state, okay, what we think the actual ruling in this case was.
Okay.
It is certainly not, administrative agencies are irrelevant or anything close. So as I understand this, what the court did was simply said that we're not going to delegate, we're not going to allow administrative agencies to have the final word on the meaning of the legislation. Okay, we're not going to let them interpret the meaning of the legislation. But we are going to continue to let them interpret the facts. Let me give you what a sort of example I think that many people could relate to. So, you know, it's like, I don't think that laws matter much anymore. I don't think that courts matter. I mean,
Yeah,
over the last
right.
years, the
Yeah.
whole legal system, the whole interaction with the government has sort of been downloaded, you know, to all these agencies. And for example, in Ontario, and probably every state, they have like a landlord and tenant board, right? And there's all these things going on where, you know, there's a statute governing landlord-tenant relations, and you know, there are problems, and so you know, people have, you know, they go to this landlord and tenant board, right? Now, the administrative agency is going to be allowed to interpret the facts, right? In other words, did somebody or did somebody not pay rent? Was a repair made or was it not made? Okay, that type of stuff is still, as far as I can see, within the complete jurisdiction of the administrative agency. But what has been removed, see, prior to Loper Bright, it went further. The administrative agency could determine as a matter of law, right? You know, what was the legal significance of this? What did the law mean? And what Loper Bright seems to be doing is saying, well, you know what? If the law isn't clear, no, we're not going to allow the administrative agency to determine the legal effect of this stuff. We'll let them determine the facts. We won't review that, but we're not going to let them interpret what the law is, right? So remember that that's, you know, that's fairly narrow, and I would say that I would read it as more a shot across the bow of administrative agencies. They need to be a little more careful. I would not read it as a massive, you know, we're taking away, you know, their authority. And this is, it's very difficult, okay? You know, once you get involved in with these administrative agencies, you get a different result. So for those of you out there, you're far better off spending the money for a good lawyer on the lowest possible level, the administrative agency, than saying, oh, well, if it, you know, if it goes south, I'll get a lawyer later, because there may not be much the lawyer can do for you later.
That's great. Yeah. Thank you, John. Thank you for that. That's absolutely, you know, and I would say, and I think that, you know, what this means, and here's a problem that we have immediately, you know, a problem that we have immediately. And I just got, you know, this is one of the things that popped up over this weekend. Let me get this up here. Do I have that? Nope, that's not the one I want. Hang on a second. Because now if you think about it, we're dealing with, you know, this channel, we deal with tax a lot. And one of the things is, well, what's tax court? What's tax court? Is that an Article 3 court, or is that an administrative agency? Right? Well, and I can't, this is behind a paywall and I'm not allowed to share it, but this is just came out that some judge is saying that Chevron ruling is no sea change. So they're saying, oh, it's not really going to do too much at all here. We're going to still rely on the IRS's and Treasury's expertise in the tax code following the U.S. Supreme Court's landmark decision to overturn the 40-year-old Chevron doctrine. So this is funny. A non-Article 3 court is saying that the Article 3 decision doesn't really matter, which only underlines the problem that Chevron created, that I think these administrative agencies, look, we don't have to respond to anyone. So while, and this is what I would say, John, I agree with your point that no, federal agencies are still there and they're still a thing, but the abuses that Chevron allowed to create, the restrictions of those abuses now are basically because my point is like, right, it's not that much of a correction back, but because how much has went off this way, right, went off the deep end, that correction is actually pretty substantial. And right now I want to go, because we have some great comments, because not everybody agrees with us. And we got a great comment here. And I think this illustrates it perfectly. Here it is. So here's someone who's, okay, looks like not a fan of getting rid of Chevron. Okay, so let's go through the analysis of why not. Okay, thank you very much for this comment. Really, really appreciate it. Getting rid of Chevron is like expecting the public to put together IKEA furniture without any instructions. Okay, interesting. Okay, pretty good analogy. All right. The federal agency's right to technical instructions to build the furniture, right? Mm-hmm. Following up, Congress is not technical enough to write the instructions. They aren't even equipped to know what pieces to put in the box. And look, by the way, I'm agreeing with you so far. Agreeing yet. All they know is they want a couch. The agencies figure out the rest. And now here's the problem.
I have
Yeah,
a
go ahead.
thought. Why don't we come back to this comment in a minute and use
Okay.
it for the basis of discussion after we go through a little more here? I mean, I think it's a very intelligent comment.
Right. It is. It really is.
Let's get a little more background,
Yeah.
before we try to evaluate that.
Okay, great. Sounds fantastic. All right. So let's get into your presentation. You ready for your presentation?
Yeah.
All right. And so, and John, thank you so much, because one of the banes of the existence of our audience is the FBAR reporting.
Yeah.
John and I have gone over multiple times the issues, how the FBAR regulation doesn't quite match up with the law. So wonderful opportunity maybe to revisit this. So here it is. All right, John, let's get into it.
So look, first of all, I want to say flat out again, that this is not and has never been, part of my general area of expertise. Okay. But where I think I actually have a perspective to add is that, my whole life, from law school, well, in the last century, has sort of, been part of this, incredible shift away from courts and over to administrative agencies. So I've sort of lived this. But let's begin. Okay, you're always fond of, going back to the founding fathers, and you hear people talk about the U.S. Constitution. They say separation of powers, and the reason for that is so that one part of government can't overwhelm another. Right? I mean, that's the whole point. And, going back historically again, I think the reason that all power tends to corrupt and absolute power corrupts absolutely has retained its vitality is because it's absolutely true.
Right. Yeah.
So continuing, let's go through this. Now, some of this stuff, look, I want to go quickly through this, and I'm not talking down on anybody, okay? Believe me, okay? But I think it's always important. Well, you know me, I always start with a statute. And in this case, the statute is the Constitution. And here's how the separation of powers works very quickly. Congress makes the laws. Next. The executive, meaning the president, who basically appoints the Treasury Secretary, among others, right? They don't make the laws in theory, right? They administer the laws. But when laws are made that include, Treasury can make regulations, I mean, it's pretty obvious that you can change a regulation quicker than you can change a law, and you can easily influence the interpretation of a law by who you appoint as Treasury Secretary. And I think that's a very important thing to understand here. Okay, so, and then third, Article 3, next, the courts are there, as sort of the referee, when, basically to prevent these sort of jurisdictional fights between Congress and the executive, who really can do this sort of thing, right? And that's not the only purpose of the courts, but it is a purpose of the courts. So these are supposed to be checks and balances in theory. Okay, they're not anymore because now this is a politically party-driven thing. But anyway, moving on. Now, in recognition of the separation of powers, there is such a thing called the Administrative Procedure Act, all right, that essentially legislates, codifies, reinforces that principle of separation of powers. And, again, for a lot of the history of this, after the Great Depression, there was all this, stuff going up. But in any case, the bottom line is, if you look here at the bottom, the APA, in short, incorporates traditional understanding of the judicial function under which courts must exercise independent judgment in determining the meaning of statutory provisions. Right now, that's very much at the root or the heart of this Loper Bright decision. Anyway, moving on.
And really, I mean, the APA, and I think this is where for a few things.
Procedure Act.
So in law school, we were forced to take administrative law, and it was the most boring subject imaginable. Because
and now it's the most important law school.
And exactly, it's the most boring one, but the most important one. Now, one of the reasons why I think I now see it as boring is because what Chevron did is it basically ignored the Administrative Procedure Act. It just ignored it because this is what the administrative state was known as, the fourth branch of government. Everyone knows it at that. Well, we're even saying it. It's out in the open. They're the fourth branch of government that isn't elected. Now, the Constitution doesn't allow for a fourth branch of government. So whatever it is, it's got to be a close eye on it, not giving it the keys of the kingdom. Right. I mean, if we were going to follow the Constitution, if we're going to do something else, okay, hey, just do whatever you want, but you don't get to claim the protections and legitimacy of the Constitution. So that's the problem with this, is that the Administrative Procedure Act was largely ignored by Chevron. It just sort of got rid of it. And here it is. Congress, and I guess President Truman as well, saw the expanding administrative state as a threat and passed a law specifically to limit it. But guess what? The entire government just ignores it. When the government finds something they don't like, they just ignore it. And
that's right. And the problem here, right, is that all these players at the table are very, very clever, right? I mean, so the Chevron decision doesn't say, flat out that the administrative agency can determine the meaning of the law. What it says is that we're going to defer to their interpretation, right? I mean, unless
the result has been.
Yeah, so I mean, in effect, it's the same thing, right? So I mean, basically, here's the context, right? You've got a constitutional structure where Congress makes the laws, the courts interpret the laws, and the executive branch are supposed to just apply the laws. And what something like Chevron does, or has the potential to do, is to allow the executive branch the power, if you will, the binding power to interpret what a law means, when that's not really within their constitutional jurisdiction. That's the problem. And, when it reaches the point that it has, it becomes absolutely intolerable. I mean, and that's why we say the Internal Revenue Code is the Constitution of the United States, Anthony, because in theory it might not be, but when you transfer all this power, to the IRS and Treasury, what's left for anything else, right? And then, of course, practically speaking, well, you can challenge this, but you have to pay the taxes first. I mean, it essentially makes an administrative agency judge, jury, and executioner. And of course, interpreter of the law, and that's the problem. But anyway,
another great comment, and we'll get to this in a little bit. Okay, some disagreeing. Chevron is a recognition that the role of agencies is to implement.
I get it.
Yeah, so we'll get to that. Yeah, so we'll get to that. So all right, right on. Okay, so move on.
Next. Again, there's a huge difference between creating or interpreting a regulation that's consistent with the intent and purpose of an existing statute on the one hand, or extending interpreting it beyond.
Yeah, there we go.
Do right. I mean, there's a huge difference. Now, in a minute, let's wait until we talk about Justice Jackson's questions in the Bittner FBAR case. Back. But I mean, the question here is, what are the limitations on the power of the executive branch to write regulations, right?
And and thank you. Yeah, and I think the FBAR is a perfect example. And I think this is actually a perfect example of where we should have some limitations, because it's really off the rails here.
Yeah. Anyway, so moving on. I just threw that in. There it is, the Administrative Procedure Act. You know me. I always like to have
I know you always do that. You always go to the source.
Sorry about that, but I think that they're it's kind of like this. Okay, who was it said that facts are stubborn things, statutes are stubborn things? Okay,
yeah, they're there, and oftentimes they don't say what people want them to say, right?
But that's what it says.
And here it is. So here it is.
All right. So here's Chevron. I'm sorry. Chevron, and I just quoted this off the Supreme Court site or whatever. Let's read this carefully. A government agency must conform to any clear legislative statements when interpreting and applying a law. Okay, so they're bound by anything that's clear, but the courts will give deference in ambiguous situations as long as the interpretation is reasonable. Now, a couple things here. Okay, one, who decides whether it's ambiguous or not? What does reasonable mean? Does that mean that any crazy lunatic could find a logical reason, to interpret it that way?
Right. Yeah. Well,
know,
John, and if I could just interject here quickly, well, what would have happened if Chevron went the wrong way? For the people that Chevron that the case didn't allow it. Whatever interpretation we were going for, and I can't remember what it was, but the court says, you know what, this is a problem. It's not here. Well, does that mean what would happen? Like, well, if it's a good idea, and that's what you want the end result of the law to be, why don't you go back to the political process? If this is really what you want and this is what you want the law to be, well, then you should have no problem. You should have no problem passing the new law that gives you this authority to do the thing you want. But what Chevron did is it short circuited the political process.
well,
That
yeah,
anything could be passed, and hey, look, whatever it is it's good enough, close enough.
let's put it
Let's
another
move on.
way. Let's put it another way. What Chevron largely did was made it impossible for people who disagreed with a decision from an administrative agency to have any, sort of a legal avenue of appeal or whatever, right? That's what it did. So really, I think a large part of the discussion is about, do we want a world where administrative agencies are the law, period, okay? Or do we want a world where we have administrative agencies, but their conduct is subject to a judicial review in a meaningful sense? I mean, that's
Yeah.
that's really the question here, I think. But in any case, moving along.
All
Oh, by
right.
the way, and that's the reason I said I think, because I know a lot of other people don't think that way. I mean, look at the Loper Bright decision. The three liberal judges dissented.
Right. Exactly. Right. And again,
Democrats, they want regulatory control, this, that, and the other thing.
right. And so I think here again, another comment, and here's more, and we'll get into this more. It's like agencies don't interpret laws; they implement law. They must take reasonable steps.
I get the perspective of this person.
And and we'll get into more of the. We're going to say like
This
you're going
is
to have some problems.
Anthony, where there's going to be significant disagreement.
Yeah.
Okay, I mean, the gentleman, whoever the commentator feels more strongly about this than I do, but I'll be honest, I don't share. That's not my view of the role that administrative agencies should have, at least not to that extent. The
Exactly.
question is not that they behave reasonably. The question is there anything you can do about it when they don't? That's the question. But
Yeah,
anyway,
good question.
moving on.
By the way, and I see we have a lot of people joining us, just hopping on aboard right now. I am your host, Anthony Parent of the Irish Medic Podcast. With me is John Richardson and Keith Redmond, and we are going over the Loper Bright decision today. And really, and I think what we're doing today is explaining it in context of one particular regulatory statute, the FBAR, something that has been plaguing people for years. If you just don't file a piece of paper with the government can take over half of your asset. And what we've seen, and this is the truth of it, the application of this regulation has been incredibly unfair. I've been doing so many FBAR appeals. I've been taking over cases. I know this inside and out. I deal with the IRS agents and employees and attorneys. This is what I can tell you, is that there is a vast difference. If you are a large corporation that does not file an FBAR and has a team of lawyers, guess what? Your penalty might be very small, if at all. However, if you are a retired individual at the end of life, perhaps inherited a couple $1 million in a bank account overseas, but you are near the end of the life and you are looking for the IRS to be reasonable, they will not be. They will hammer you, and they will hammer you specifically because you can't fight back. And that's the truth. That is the truth. That's the truth of being inside the system. So whatever theories you have, let me tell you about where the rubber meets the road. The powerful, they don't have a problem with this. It's the same appeals officers. You will get vastly different results depending on how powerful your client is perceived to be. So that's the truth of it. So we're going to go through it. Next slide, John.
Okay, so this brings us, to present day time, and we all know what happened last week. Loper Bright, the decision came down. Let's see here.
Oh, you want to hit the summary?
No, you can stay there.
Okay.
Okay. Well, anyway, so basically, I think it's an important but fairly narrow rule. I mean, what it says is that in the case of a statute being ambiguous, that no longer is the law that they're going to defer to the interpretation of the agency on it.
Well, and I would say this, and this is also the thing too. This is not a case of where the Supreme Court actually created the law and interpreted it. They're just saying your interpretation isn't good. Go back and create a better interpretation.
Yeah, I think we should not go too far on what the case says. All the case says, okay, is that if the interpretation of the statute is ambiguous, all right, we are no longer going to use the Chevron standard, which was that we're going to defer to the administrative agency's interpretation of what the statute means. No, we're not going to do that. That's not their job. Our job under the Constitution of the United States is to interpret what the statute means. That's what they're doing. That's all they're doing. Okay. And I really don't understand why somebody would complain about that. Okay. I mean,
Well, there's a whole industry built up around
you know,
their house values around Washington, D.C. will crater. That's the fear that Chevron built up an entire, the amount of wealth. It's incredible, the growth that has happened around Washington, D.C. Something that doesn't appear to, they don't seem to have much of an industrial base. You're trying to figure out, well, how do these people get so rich here, huh? Yeah.
Look, let's not run away with this. The fundamental question, the concern, it's like we talk about all these people that, as though they're disconnected from the lives of normal Americans. I see this somewhat differently. Okay. The real issue here is whether a plain old vanilla working class poor American guy trying to survive should have some protection from government overreach or not. That's the question here. Okay. And, so here we have a 6-3 decision that, I don't think it's huge, but it says, yeah. You know what? Normal people are entitled, okay, to have the meaning of the law determined by courts and not by the administrative agencies that trying to use it to enforce it against you. That's what the decision means.
No, the decision says that no, Congress needs to write laws that are more closely related to the regulations that the agencies are going to impose. It's essentially, it's like the courts are, the way I look at it is like the courts don't want to insert their interpretation. Others say, look, we have to have some better, closer relationship with your regulation and law. That's
as far as I can see, the decision just says that we're not going to give the administrative agency who's interpreting the law to enforce it against somebody in a specific way. We're not going to give them carte blanche to interpret the law. I think that's all this decision says. Okay. Yeah. Maybe I'm wrong, but if you look at it from that point of view, why is everybody upset about this? What, they want a world where, an administrative agency can be judge, jury, and executioner? Yes, I'm an American citizen. I live in this free constitutional democracy. But by God, this administrative agency that's just messed up my life, there's nothing I can do about it. And I think that's fine.
I should just be happy with it, right? Just like, hey, I'm lucky to be American. I'm lucky to be in the greatest country in the world is what you're
saying. Let's continue on.
All right, let's go on.
All right. So the summary, okay, here's what Justice Roberts says. Chevron is overruled. Courts must exercise their independent judgment interpreting whether an agency has acted within its authority as the APA requires. Okay, now that's important. Okay, that's important because, for example, if a statute gives Treasury the authority to make a regulation for a certain purpose, they can't go further than that. But I think that's fairly obvious, okay? I don't think you needed the Loper decision on that. Let's see. Careful attention to the judgment of the executive branch may help inform that inquiry. When a particular statute delegates authority to an agency consistent with constitutional limits, courts must respect the delegation while ensuring the agency acts within it. But courts need not, and here's the key, courts need not, and under the APA may not defer to an agency's interpretation of the law simply because it's ambiguous. That's what the decision says. The first part, I would hope to God, would be a self-evident truth that government agencies can't make up regulations for reasons unrelated to the statute. But I'm glad he said that because no doubt there are, particularly in the Treasury Department.
Yeah, no, we're going to be going over one.
Okay. And then we have, the author of this article. It was a great article. This is the link I sent you. I don't know this man, but it was a great article. And here's what he's saying. It says, in short, the impact of this case is substantial. Well, the court explained that its decision today Loper does not call into question prior case. So in other words, it's not retroactive. That relied upon Chevron will certainly impact a slew of new regulations implemented by the Biden administration on the environment and many others as we inch closer to election day. Rather than deferring to these agencies' interpretation, courts will now have to exercise their own independent judgment in determining the legality and constitutionality. Well, yeah, but I think that's a somewhat broad reading of the case. But okay, look, again, the dividing line is very simple here. Those who, want the world run by administrative agencies are going to be upset by this decision.
Yeah, right.
Those who believe that people should have recourse to a court on issues of the meaning of a law, recourse from these decisions are going to think it's good. I mean, I don't think it's hugely broad, and I think it makes a lot of sense. But anyway,
no, it's just saying, hey, no, the law that Congress passed in 1946 is a law and it applies. That's basically all it is. It's saying, hey, yeah, right. This issue was decided on by a Congress and a president. They put it into law. We're just going to honor the law, the APA. That's really all it is. I mean, think about it.
Yeah.
So I have a question. So at the end of the day, the world is going to go back to how it was before Chevron.
No,
correct?
I don't think so.
Yeah, you would think so. I don't see that because you have 40 years of inertia that, and essentially, and really, 40 years, people have been in, this, I was born in 1971. Chevron's been basically the law since 1984. So you have a whole bunch of people who can't even see past it and even see why Chevron's a bad idea because the way that, this is what I would say here. This might be a good point to say that, the problem given to say, and let me just go back up to this comment here. Let me just go back to this comment. Where is it to, the problem that you have with Chevron is that it takes laws and takes them to mean things that they can't be, and there's no way to account for them. Okay, and let me just grab. There's one comment that I just wanted to grab because I think today. Oh, here it is. This is the one. This is one I wanted to address. Congress is not technical enough to write the instructions. They aren't even equipped to know what pieces to put in the box. All they know is they want a couch. The agencies figure out a rest. Okay, and you know what? This comment I really like because what we're saying is because this is the first thing we need to accept, and if we don't accept this, then Loper right's not going to make a lot of sense. That the federal government is actually to only have limited powers. Okay, and that by creating these three branches of government, where Congress must write the laws. The executive branch must execute them, and that Congress is supposed to interpret them. That assumes that laws are going to be easily understood. But what we try to do with our laws, and especially in the areas of tax, these are the most complicated and discriminatory. Discriminatory taxes are imaginable. Everybody is you're treated differently based on who you are. There's no equal application of a law. So what Chevron does is because without Chevron, without Chevron, there's a practical problem you have in trying to rule over every little aspect of people's lives. Is that, well, you can't because it's too hard. So what Chevron did, and I still think will allow to a large degree because courts don't like following things that restrict their power. They just ignore them, right? And even we saw that Treasury, the beneficial ownership information reporting form was deemed unconstitutional by a district judge in Alabama because saying, and this is what the federal court said is like, hey, look, there's no authority whatsoever for Treasury to regulate what is purely an intrastate activity, which is owning a limited liability entity. So that case, it's going to be appealed, of course, but that judge was very clear. There's no power to do this whatsoever. So what has a U.S. Treasury interpreted that ruling as? Well, if you go to their website, they'll say that this ruling only applies to those particular plaintiffs in this case. It doesn't apply to anybody else. And so they're still going forward with the board reporting, even though a federal court says you don't have any authority to do this. And so that's what we need to understand about these headless governments, that they're more, that this administrative state, well, they're going to still kind of interpret things their way. They're still going to do it, even though when they're told like, well, you shouldn't be doing that. Well, they're still going to do it because of the inertia, and it's just sort of cultural at this point. So I'll move on now. I thought that was a good time to mention that. So here we go.
So, the risk of
perfect.
articulating the obvious, right? I mean, here are a number of regulations that directly affect the lives, through Treasury regulation. Now, I want to point out some things here. And this is, for listeners, this is very important, very important. Okay. So listen up here. All right. If you're at all interested. These particular things that I'm listing that probably only Americans abroad are well aware of that affect your lives,
Right.
penalty base. Every single one of these, with the exception, I'm taking back every single one of these. And yes, I selected them because every single one of these. So yeah, I agree it's self-selection. But it's self-selection for most of the stuff that affects your lives.
Absolutely. Absolutely.
Okay. Every one of these are based on regulation and not statute. Every single one. Now, Let me take you through this briefly because I think this is such an important point. We know that FBAR section 5314 in effect just says, hey, Treasury, make up a bunch of rules. And it's the regulation that's the law, not the statute. But we'll be talking more about that in a second. Okay, Form 5471 is a reporting requirement found in Internal Revenue Code 6038. I emphasize, all of the rules for 5471 are the product of Treasury regulation, nothing in the statute. Next, every time I mention this, people are shocked. They don't believe me. But the Internal Revenue Code doesn't define what a corporation is, doesn't define what a trust is. I'm not kidding.
It's true.
Those definitions are absolutely and completely the product of Treasury regulation. Now, you may think, so what? Well, let me tell you something. 1996, many of the worst abuses of Americans abroad come from the Clinton years. Okay. In 1996, Clinton Treasury, redid the regs defining what corporations were. And, there were reasons for this that I won't get into, but the point is that they redid the regs. As part of redoing the regs, they deemed all Canadian corporations, including all these small Canadian private corporations, to be deemed per se corporations, which sentenced every single one of them in 2017 to the GILTI rules and the transition tax. This is not the law. This was the regulation. So people who think this doesn't matter, well, you're pretty dumb, okay? Same thing with trusts. Okay, right now, okay, there is the Treasury Department is revisiting the rules for foreign trusts and foreign gifts, etc. And I wrote a comment for Seed, a lengthy thing that's going up, and there are a number of other comments, okay? But see, my point is that if you look at the definition of trust under the regs, because there isn't one under the Internal Revenue Code, not a single one of these things that people are complaining about, Canadian TFSAs, Australia, these aren't trusts by that definition. I mean, this is beyond insane, right? Filing threshold for foreign gift, you receive a foreign gift. The statute says $10,000. The Treasury notice regulations say 100,000. Okay. The reporting rules for foreign trusts, tens of thousands of people have received $10,000 penalties for stupidly filing Form 3520 for things that weren't trusts. Okay. And then what about Form 8938? Okay. Et cetera. I think we've lost Anthony here. So we'll wait for him to come back.
Sure.
But, again, for listeners, this is not, you may view this as a bunch of theoretical gobbledygook, but this is where the rubber hits the road in your life. And this is why, this decision matters and matters a great deal. Okay. because without a decision like Loper Bright, it becomes infinitely more difficult to challenge the legality of this type of stuff.
So this could be a good thing for Americans overseas moving forward.
Well, look, I think that this is a good thing, for all Americans. I mean, it's a good
Right, generally speaking.
American who believes that that individuals ought to be able, at least in theory, to have some protection from administrative agency overreach. It is not a good decision for people who think the opposite. And
Right.
to be very, very clear, there's all kinds of people who see it as exact opposite. I mean, they do not want people to have protection from the government. They may not frame it that way, but I mean, anybody who opposes Loper Bright, that's what they're really saying. Okay, and I'm not, I mean, I understand the rationale for things like Chevron, and I don't think it's complete. What eventually happens is that power corrupts, and absolute power corrupts absolutely. So, if the Chevron decision is interpreted to mean that, administrative agencies have absolute power, the next step is that they're going to be corrupted absolutely because of it. I mean, that's just a historical fact. So, welcome back, man.
Yeah, sorry, my browser crashed. That was so nice of it. On it could sense my excitement over it. That's the problem.
So I mean, there's where we were in the thing, but do y'all see why? Particularly in the context of Americans abroad, this is really significant because they are ruled by regulation much more than law. I mean, even citizenship taxation, if you will, is I believe mostly a product of regulation.
This is what I wanted to ask you, John, because this is the point exactly. When we talk about, because you said, look, we have a corporate income tax. We don't define corporation. We have an income tax on trust. The law doesn't define what a trust is. Now we have an individual income tax. Does the law, other than saying individuals can be married, divorced?
No, it doesn't. It doesn't. Individual means any carbon life form, and then you have a carve out for non-resident aliens. And the Treasury regulation clarifies by saying individual means a citizen or a resident. So, in other words, the whole citizenship taxation regime could be changed through Treasury regulation. And this is an article that that I wrote along with Laura Sider and Karen Alpert a couple of years ago. Called A Regulatory Fix for Citizenship Taxation, where we explore this.
Right. So and this is what I say. People will say, "Hey, point me to the federal income tax law," and actually, you can't quite do it because it's the regulations that really define the law. Now, isn't this a fantastic time to sort of show what the problem is? Because why doesn't the individual income tax law define what an individual is? And the answer is because someone in Congress would be responsible for that vote. So, hey, we're going to have this individual income tax law. We'll let others go to these other issues. It sort of takes away that accountability. Why isn't a trust defined? Same thing. Because, because somebody voting for a law doesn't want to be accountable for the results of the law. So make it ambiguous. And then you just blame it on these. Hey, you didn't hear it. They always blame the unelected bureaucrats, the ones who they empower. So that's kind of what we have here. And this is, I think, a perfect example of how much we are ruled by regulations in the issue of tax. Basically, all of it is. Yeah. Because none of these things are defined by the law. They're all defined where these critical, important factors are all decided by regulations.
Well, certainly, and more so in the case of Americans abroad. There's no question about it. But I mean, so this kind of sets the stage. So let's move on here. See what else we got. Okay, now, I know you love thinking about Mr. FBAR, and I mean, I think that FBAR is probably the best manifestation of sort of lawlessness, arbitrariness, and tyranny in the United States. You couldn't make up anything worse than this. But let's consider the FBAR thing, right? So, the starting point is, of course, we don't have to go there. We've been there so many times in the past. But the enabling statute, basically just says, hey, Treasury, we're going to let you make up a bunch of rules.
Well, I think we do need to go there really quickly. Let me just go there quickly there. Let's
Sure.
hold on. Hopefully my computer doesn't crash like it did last time. Okay, here it is. So this is what we're talking about. This is the FBAR law. Okay, 31 USC 5314, records and reports on foreign financial agency transactions. We've gone over this multiple times. By the way, this was not a part of the Bank Secrecy Act of 1970 at all. That is not true. This was a currency regulation, as John has correctly pointed out. So this is the thing that says that you have to file an FBAR. Considering the need to avoid impeding or controlling the export or import of monetary instruments. A monetary instrument is not a bank account. It's something that moves in transit. And the need to avoid burdening unreasonable a person making a transaction with a foreign financial agency. Okay, so the purpose of the law is to make things easier when you're dealing with a foreign financial agent. The Secretary of Treasury shall require a resident or citizen of the United States or person in and doing business in the United States to keep record, file reports, or keep records and file reports when the resident citizen. And by the way, this obligation, as John points out, is on the Secretary of Treasury right now. The Secretary of Treasury is the one with the obligation to.
Yeah, Anthony, to put it another way, okay, I mean, this is astounding. To put it another way, no individual, nobody but the Treasury Secretary can violate 5314.
Right, the way it's written. Right, the way the actual way it's written. And now here we go. And it says with a foreign financial agency. And by the way, an agent is defined by the law. An agent is an actual person. They may be acting as a bank, but they have to be a person. And a foreign financial agency is not equivalent to a foreign agent. The law makes that clear. They are actually two distinct things even though the rules they can overlap at point, but we're still dealing with the import and export of monetary instruments. Well, look, if you could import a foreign bank account in the United States, it would no longer be foreign, and it's also a bank account. And now here we go. The records and reports shall contain the following information in the way and to the extent that Secretary prescribes. The identities and addresses of the participants in the transaction or relationship. Doesn't do that, right? The legal capacity in which the participating is acting. Doesn't ask that. The identity of the real parties in interest. Nope. There's no real parties that mentioned other than you. Description of the transaction. There is no transaction. There's no transaction whatsoever. So 5314 is so vastly divorced from what the FBAR statute is. I always was like, I don't even see how it could have survived the Chevron standard is where I'm at. I'm like, I don't even see it's so unrelated to the actual law. How does this survive? Even a Chevron standard. And now, with Loper Bright, I think that, they got some serious.
Well, I think that with Loper Bright, okay, I don't know for sure, and I want to resist making sort of sweeping inferences here, but I would point out some of the commentary on this has gotten a little more granular and said, well, what kind of a regulation is it? I mean, is it, are we talking about Treasury's interpreting an existing definition of something, or is it something that, basically enables Treasury to completely make up the law, right? Does that make a difference? So I don't know the answer to that. I mean, these are the types of things that obviously for the next 50 years, the courts are going to deal with. But I mean, clearly this is an example of, I think that under the Constitution, this is possibly an unlawful delegation of legislative authority. It's so unbelievable.
Yeah, it's unbelievable. Yeah. All right, now this is what we did. Yeah.
So, Bittner, of course, was heard by the Supreme Court, and the decision came down last February. And I remember listening to this during the hearing. Was the Bittner case was about the interpretation of the statute, right? And the case they were dealing with was whether under the penalty provisions for a non-willful FBAR penalty, the penalty was limited to $10,000. But the point is that the case was about how to interpret the statute. And Justice Jackson, there was a very interesting exchange between Justice Jackson and I think the Bittner lawyers. And I remembered it, and I, putting this together, located it yesterday. And this is fascinating. And I'd like to go through this with you because, this exchange shows you, I think, it sheds some light on what might be the permissible interpretation of what this was actually being intended to do. So Justice Jackson, counsel could that possibly be? Is this the first one, or is this?
Yeah. This is the first one. Yep.
They're talking about, we're assuming that Congress was focused on accounts when it's possible they were focused on the person. Very interesting. What exactly?
Whoa.
Who is the statute designed to apply to? Okay, is it about the accounts or is it about the person? So the thing that I'm trying to get my mind around is the fact that in 5.3, I don't even see the word account. It says, it refers to persons who make a transaction. So let's pause and think about that for a minute. Why are we talking about accounts? Well, because they're in the Treasury regulation.
Right.
But what she's saying is, whoa, hey, over here, look over here. Here's the law. Let's start here, okay? So continuing to read on. So first of all, we have no account word in the statute. And then when I look at the history of it, it appears to me, and you might correct me if I'm wrong, that Section 5314 originally directed the Secretary to require any resident or citizens who engages in any transaction or maintains any relation to file this record. Okay. All right. So, she's thinking out loud. Next slide. Okay. And when they amended the statute, they said they changed it to the language that exists here, but said this is really not a material change. Okay. So in other words, it's not a material change. They're still focusing on the person, not the account. So that's kind of how we're looking at it. Then I think maybe we're not even being directed by the statute to care so much. Next. About the accounts, because what Congress was trying to do is give the Secretary information about who was engaged in these kinds of activities, focusing back on the person. Not what do they have, but who are they, right? There's a difference between everybody with a foreign account, raise your hand, and everybody with a foreign account, report those accounts. Those are two very different concepts, right? And then she's saying, then the Secretary could go afterwards and then ask them for more information. There's that, and then she says, there's that provision about the 25 accounts or whatever. You don't even have to give the information. So as long as the Secretary knows who's involved in this, then they have the essential nub of information they need to do further investigation. That's how I'm looking at it. Now let's pause here for a minute. That is, I think, unbelievably significant, right? Because here we have, Justice Jackson, whose mind hasn't been corrupted by years of looking at FBAR cases, doing the unthinkable. The unthinkable. We start with the law. What does the law say? Okay? And by the way, this is what Loper Bright is really doing. It's saying, let's start with the law. What does the law say? Right? Okay. So, so then you ask yourself here, is this FBAR regulation, this thing that we've talked about? Is this possibly subject to challenge under this Loper Bright decision? I don't know.
Well, now, because of the court says that we're not going to disturb any other rulings under Chevron. That's what they say, which is sort of an interesting thing. But
Yeah, regulation.
Bittner did not decide this. Bittner was only deciding whether or not the penalty was on a per account or per form basis. That's what it decided, but it didn't go to the overall authority of the report in the first place.
Bittner,
so in my mind, it did not address that. And because what's that, John?
Bittner did not talk about the regulation. I don't believe it was completely about the proper interpretation of the statute. Right. That was the whole point here. But look, again, what do I know? Nothing. Okay. But I'm just kind of looking at this and trying to understand this in the context of something that we have thought about a great deal, which is this, really sort of obscene and incestuous relationship, right, between, the government and Treasury, right, when it comes to making up these regulations.
Yeah. And here's a comment that is like generally for the panelists. Do you believe do you believe that less federal regulation is always better? Well, I would say you're framing the question incorrectly. What I'm saying is that regulations need to follow the law. It's not a relevant question, right?
It's not material. It's not
no,
material.
no.
Continue on.
Okay, so
So
here we go.
what does this thing mean, right? I don't know. I mean,
Right.
I think it's good, right? I'd rather have it than not. I don't believe this is going to, at least in the short run, I don't see massive changes here. But I mean, here are a couple of, I just pulled these off Twitter, commentary from tax lawyers. Here we have Justin Miller, who I don't know him. I don't know either of them, but he seems like an intelligent guy. And he says, well, Treasury and IRS for the past 40 years, don't be a fool. This is the rule. Treasury and IRS after Supreme Court strikes down Chevron doctrine. We think it's the rule, and I hope you agree. But if not, we'll have to go to court to see. Right? See, really, he's a poet masquerading as a tax lawyer. But I think that's right. I think that's right. Yeah. Okay. Or at least hard to challenge, narrow. I mean, he's a lawyer.
Yeah, and now here we go, and again, we're going to see.
Now sort of the practical. What do you do in a post-Loper world? Well, Congress could write more comprehensive laws.
No, they can't. Congress doesn't write laws.
You mean the staffers? Well, I think
no, right. Congress doesn't write laws, so that's ridiculous.
They might be clearer about their intent to whom it's supposed to.
Yeah.
Codify Chevron. Now that's interesting.
Yeah, well, right. Basically, Congress could codify an illegal action, right? And I mean, you're kind of like, well, we're going to just ignore the Constitution. So we're going to, we're going to allow agencies to create regulations out of thin air. It's basically, I mean, that would be easier for Congress. I'm sure they would like that, really reduce their workload.
Well, I mean, this is about being, on one level, there's no question, this is about Congress just being lazy or recognizing they're stupid. One of the
or I mean, there are limitations. Their job there is to, their job is to sign whatever's in front of them. And they get, they get the ability to make insider trades on industries they regulate in return. So it's pretty simple. It's a pretty simple, straightforward. I think it's a pretty simple, straightforward scam. They just sign what's in front of them. You want me to sign this? Great. Okay. Now I can trade. Yes. Now you can trade. Here's what's going to happen. Why? How do we know that? Oh, because you're the one who's going to pass the law. Oh, wow. This is great. And that's why, if you follow who's at their Unusual Whales on Twitter, you'll see all these fantastic, magical trades of all these Congress people. Just happen to be incredible traders. But why won't they trade? Their incredible experience with us lowlives who don't have the ability to have the insight they do. Why don't they share that information with us, right? All right, so let's move on here. Last one. Courts could create a new consistent framework for interpreting ambiguity so we don't have a patch.
I doubt they could do that, but anyway.
I don't know what that means.
I mean, my point is simply this. Nobody knows, okay, right. Really, where this will go. I think it's nice. I think it's a nice decision, but I think initially it's going to be more of a feel-good decision because it's going to take a lot of time to figure out what this means. And Keith, to add to an answer to your question a little while ago, right? I mean, so you say, the court says, well, we're going to give deference to the agency on matters of fact, but we're not going to let them have the authority to interpret the law in ambiguous situations. My recollection of a lot of administrative law is that a huge part of it is trying to determine when the interpretation of a fact is the interpretation of a law or vice versa. So I don't see this making much difference for a long time, and gradually. That would be my guess. But again, what do I know? Right.
Well, I would say that assumes we stand by the sidelines there, John. But Keith, because this is what I just want to interject right now. I do believe there's a refund suit potentially. I do believe there's a refund suit for everybody who's been forced to pay an FBAR penalty or been forced to pay an offshore penalty in lieu of an FBAR penalty. I do believe that, and I do believe that the Court of Federal Claims would be the appropriate jurisdiction. I am very interested if there are any practitioners out there, because I would love to get you on the channel, love to get your input on whether or not looking at whether a potential challenge to FBAR penalties and a potential refund case would be possible. So I want to share with you my actual email address. Here it is, aparent@irsmedic.com. If you are a practitioner and you happen to know a little bit something about this, you're curious yourself. Again, I am not licensed in the federal court of claims, and I have no experience there either, which is probably equally as dangerous. So if it's something that's your specialty and you're curious about this, I'm sure we could find a bunch of clients. And I think the IRS has bragged about $10 billion in penalties between FBARs and in lieu of FBAR penalties. It's collected. In my mind, all of that has to be coming right back. They are not.
How would
yeah,
that
go ahead,
work?
Keith.
I'm just curious, just from your perspective, how would that work? Because isn't this ruling not retroactive? So
Well,
people have
Not retroactive.
What they're saying, Keith, and that does seem to be something that would be a problem with it, is that the Supreme Court says we're not going to apply a Loper-Bright decision to all the things we've already applied a Chevron deference to.
right.
So it's an issue that has been decided, and the Chevron deference said, hey, it's good enough. We're not going to go back and say a new challenge to it. The issue here, and what John just presented, was that in the Bittner case, this issue was actually not challenged, and there's never been. And I was sort of angry that Justice Jackson was getting so close to seeing there's no authority, but she didn't rule on that. They ruled on a totally different issue. So as I'm seeing it, there's never been a challenge. There's never been a decision where a court has ruled the Chevron deference applies to the Treasurer's interpretation of 5314 as prescribing an FBAR. That has not been done to my knowledge. And again, if anyone has information to the contrary, I would love to hear that. I do think this is really a really significant issue, that the FBAR is a complete, and that's what's so crazy about this, right? When you're going through, what are some of the craziest things you can be penalized for as an American? What are the craziest things that could completely ruin you? And it's this, that you didn't file a piece of paper showing that you own a bank account, but which, by the way, Treasury has gone on to interpret things much more than a bank account. I mean, way beyond what a bank account is. They will go to, they were even claiming that an online account that you have in a poker site was a bank account. They got shut down on that, actually. But they've actually been making claims about anything's a bank account. If it's money and it's overseas, it's a bank account and you're subject to penalties. So the thing about this is that you have the most horrific penalties regime that you could be subject to, and yet there's no authorizing law. For it. It's the worst thing ever. If there was a law, if there was actually a law that required this would be one of the worst laws ever passed. But the fact is, there is actually no law. So it is really truly the invention of regulation. And that's where I think we often just say, this can't be right. I mean, if this is the end result, if the end result is that you don't need to pass a law to ruin someone, you could just do it by regulation, then I think we got to say, you know what, we got to take a look at these regulations, and maybe, Treasury needs a correction. By the way, Treasury is actually rewriting its proposed FBAR regulation. And in my comment, I said, you know what, guys, I don't know if you could survive a Chevron deference as is, but if Loper-Bright comes back and limits you, there's no way your regulation, should pass muster. You must conform your new regulation to conform with Loper-Bright, is what I put in there, not knowing Loper-Bright would actually overturn Chevron. So the Treasury is fully aware. I made a nice big fat comment. We had a few episodes around that. We had a big comment. So they're aware of the problems they have with their own law. We'll see what they do with it, because they love the control.
Something that you guys didn't bring up, and I'd like to get your input on, if you have any thoughts, is with this ruling, does that have any effect on FATCA at all?
Wow. Yeah. Oh, thank you for that. Yeah. So on FATCA, and that might be in other podcasts, but I'm wondering about the IGAs on FATCA, John. What are you thinking about that? You think there's anything to potentially look at there with the intergovernment agreements that are effectively treaties, if you will, treaty by regulation? Do you think there's anything to that, John?
I don't know, but you can be sure that their first response would be that it has nothing to do with the IGAs. I mean, I'm sure you'd have to clear that hurdle. I mean, let's look at it this way, okay, for a minute. When we look at these tax rules in general. So, the FATCA Chapter 4 of the Internal Revenue Code, right? If you want to pull it up, it's section 1471. But before you pull it up, it's only 4 sections, right? And, so then you get regulations of hundreds and hundreds of pages, right? Based on these 4 sections, right? So, I mean, it's very, very clear that, there's an awful lot of delegation there, right? There's an awful lot of delegation. And the question is, I suppose, to what extent does the delegation go beyond the intended purpose or not? But
Yeah.
look, this is the problem with all these technical discussions here. And I want to go back to what I said earlier, which I think is the right way to look at this. Do we want a world where individuals who don't have millions of lawyers surrounding them and at their disposal, do we want a world where individual people of modest means should, at least in theory, have some protection from the tyranny of these administrative agencies? If yes, then obviously Loper Bright is a good thing. If
Right.
no, then it's a bad thing, right? It's really that simple. This is not a question of regulatory policy. It's a question of which vision of society and the political order do you believe in? One where the individual matters? If so, Loper Bright's good. If not, if no, then you don't want the Loper Brights. I mean, it really is that simple. That would be my law, and then the further discussion would be a bunch of regulatory, backing it up, right? The details. But I don't know how anybody. Well, but I'm not being critical because I understand that reasonable people can differ on these issues. Okay, but this is not about regulation. It's about whether people should have any defenses to being subject to unreasonable regulation. That's what this is about, isn't it?
It does. Yeah. Right. And then amazing. All right. So this is going to be, thank you so much. We had a great audience today. Really
I want to get back to the question, by the way, we're going to discuss.
Oh, we also, I don't want to, I have to get going here. We're way over on time. It's been, and we will have to pick up more of this later. But one question was, how does this impact Moore? Well, obviously Moore was decided within, weeks of it. So I imagine the Supreme Court was aware of decisions. I don't see it impacting Moore, the decision in this way, right? Because Moore was an issue not about, because there was a statutory basis for interpreting or for creating the transition tax. There really was. Now, there might be something else around it. I haven't looked in it, but I would say generally my first impression is it's totally separate issue. Moore had all different problems with it. And I would say this, and generally, and here's one more. I have time for one more comment. I'll just take this. Post Rose, isn't there potentially a 14th Amendment claim that for the FBAR, it's a pure nationally based discrimination at this point? Well, I mean, yes and no, but by effect, yes, it is. But it'd actually be a Fifth Amendment charge because we're not talking about state action. We're talking about the Fifth Amendment.
Well, I think that the whole on that point, right? I mean, so the ROST thing basically said that a dual resident taxpayer who could use a treaty to claim non-resident status would escape the FBAR thing, and a U.S. citizen could not, right?
Yeah.
So I think that the ROST decision is perhaps an example of what happens when you allow a certain group of tax residents to not escape the application of a law precisely because of their American citizenship, right? So, I mean, that's how I think you would view that and frame it. And, from that perspective, this is just one more instance supporting the argument that citizenship-based taxation by its very nature is unconstitutional, right? By focusing on citizenship.
Right on. All right, we're going to wrap it up today. But again, please be sure to subscribe. We have a lot of new viewers today. Thank you so much for joining us. I am your host, Anthony Parent. Let me get my banner up here. Doing it all this morning. Let's get up. Where am I here? There we are. Here am I. I'm merged with a new firm, DeVos and Partners. You can find us there. Same, but you can still reach us out at irsmedic.com. If you do have an international tax issue going on, we help out a lot of people around the world. We really enjoy the work. Go there. You can book a time to speak with potentially with me, but one of my staff as well. And also, if you are thinking about renouncing, it's something you have a tricky situation, I can recommend no one better than John Richardson. You can reach him at citizenshipsolutions@proton.mail. And Keith Redmond. Keith has been doing a great job. Keith is actually the one I think who brought us together, me and John. I mean, honestly, Keith has been doing a fantastic job nurturing the community most impacted by these complicated regulations of which we speak. That is the expat community. What the United States government wants to do to its citizens, they always use as a trial balloon overseas. We're seeing a lot of those things coming home now. So overseas is your canary in the coal mine. Where the IRS is going, it's demonstrated overseas. And so that's really why we focus on this, because it's the most challenging, most brutalizing, most dehumanizing part of taxation is how it impacts the individuals overseas. So Keith has created a fantastic group on Facebook, a sort of a help group. Keith, thanks so much for that. And also, Keith, people who are kind of wondering what they should do, should they, maybe they're not in so much compliance and they're kind of hearing this stuff and they're wondering what they should do. And they don't want to really reach out to a U.S. tax professional first, which I don't blame them. What should they do?
Well, they can certainly contact me because, what I do is, we explore all the options based on the person's particular profile and circumstances.
Yeah.
And then formulate a strategy, whether that be a short-term or long-term strategy, and go from there.
Right on. And you want to be afraid of the people who scaremonger. And Keith is fantastic. He'll just tell you what the actual truth is. Whereas the tax industry, it's very easy to scare people into doing really insane things. And unfortunately, when people are scared into doing insane things, it creates bigger problems, which, by the way, we're experts at cleaning up. So that's something to think about. So for that, I want to, again, thank everybody for participating today. And we will be coming back to you with more analysis. And I think Loper Bright is really going to take another look. I think we can really start taking a look at other things as we go along. And if you have any things that you think we should be covering and we're not, any insights, any things, because I get some of the best tips from my audience. Again, here's my email. Email me at aparent@irsmedic.com. All right. For John Richardson and Keith Redmond, this is Anthony Parent of IRS Medic. Thanks for watching.